being in this courtroom driving against court orders while pending cases are happening. This is constant, well before Mr. Loftus was ever involved in representing you. If there's one more incident between now and the next pretrial where you come in to this court having gotten another citation, you might as well just walk to the jail. I'm fed up with you. I can't believe I'm letting you go. I can't believe I'm letting you walk out this door. It's constant with you. And I don't get why I keep being so generous to someone who just thumbs his nose at me. Get your client out of here. I don't want to see his face until the next pretrial. Bond is set, $5,000, personal recognizance, not to operate or be in the driver's seat of another vehicle. Thank you, Mr. Loftus.
Can you see now why I actually like
plea options I just explained to everyone?
Yes.
Do you have any questions regarding any of those?
No.
Do you recall receiving a copy of the
Yes.
citation that was issued on November 1st, 2022?
Yeah.
Okay. You're charged with 2 counts. The first charge is driving under suspension. That is a first-degree misdemeanor. If convicted of this offense, you face a maximum 180 days in jail, a maximum fine of $1,000, and I could impose a license suspension of up to 1 year. And this is a 2-point violation. So do you understand the consequences you face if convicted of that charge?
Yes.
The second charge is use of headlight beams. That is a minor misdemeanor. That is punishable by a maximum $150 fine and court costs. Do you understand that?
Yes.
The officer, I don't know why he checked not applicable on the ticket, but it is very applicable. If you need to provide the court proof of insurance that on the vehicle you were driving on November 1st, 2022. If you're not able to provide this court proof of insurance on the vehicle you were driving that day and are convicted of this offense, you do face a mandatory non-compliance suspension with the Bureau of Motor Vehicles. Do you understand that potential consequence?
What did you mean by non-political? What I was saying?
Take her into custody. Did you just use the F word in front of these kids and in front of me? Did you just do that? Take her into custody, go down in jail, and then think about what you just said to me in this courtroom in front of these kids, and then maybe, just maybe, I might take your case up later today. Okay? Go. Get out of here.
Sir,
Get out of here.
Hey guys, welcome back to another Courtroom Breakdown. Today's episode is going to be intense, full of drama, and might just have you questioning how some people manage to keep pushing their luck. We've got 2 defendants who seem to think the rules don't apply to them and are about to find out just how wrong they are. From reckless driving to insults flying in front of kids, yeah, it's about to get wild. And trust me, you're not going to want to miss the twist at the end. Let's jump into this and see what happens when you cross the wrong judge. Make sure you stay tuned till the end and let us know in the comments. Who's the biggest idiot here?
State of Michigan versus Bradley Peterson. Okay, counsel, you're Mr. Pervin Keller, your name for the record, please.
Good morning, Your Honor. Yvonne Parabon Keller, P84328, appearing on behalf of Mr. Bradley Peterson, who is present today in the courtroom.
All right, thank you. And Mr. Peterson, for the record, please.
Bradley Thomas Peterson.
All right, thank you. And Ms. Bella, your appearance for the record, please.
Good morning, Your Honor. Michaela Vella on behalf of the people, P87185.
All right. And so today is the date scheduled for a probable cause conference in this matter. And counsel?
Your Honor, I had the opportunity to speak with Mr. Peterson in the breakout room, and this is something that the court may be aware of, and I am not. Mr. Peterson had recently come out of being incarcerated for the purposes of these proceedings. He got out on bond, and that was arranged. Mr. Peterson and I had discussed a number of things in the breakout room. We discussed going forward with strategy in this case, and Mr. Peterson had informed me that he had filed a motion with the court to remove the judge from this case. And regardless of whether that motion had been filed or not, or whether he intended for such a motion to be filed, I advised him that I was not comfortable with doing so and that I did not agree to do so for the purposes of this case. And as such, him and I discussed that this was going to be a stopping point in going forward with representation. And as such, we parted amicably. And at this time, I would ask to be allowed to recuse myself from this case, Judge.
Okay, folks, can we just take a moment here? This defendant, Gregory, is literally asking for jail time, out on bond for driving without a license. But what does he do? He keeps getting behind the wheel. And here we have the judge just laying it out. I can't believe I'm letting you walk out of this courtroom. The judge is fed up, and I don't blame him. This guy's not only ignoring court orders, but he's also putting everyone on the road at risk. And then we have the classic defense. I didn't know. Please, let's be real. No one's buying that.
To be removed from this case because Mr. Peterson filed a motion on his own and not with discussion with you, and you're not comfortable with that motion.
That is not the sole reason, Judge. Mr. Peterson insisted that the only way that he would be comfortable with me representing him in this case, is if I continued and persisted with this motion. I do not agree with the motion that he is filing, and he said that he would prefer to go on his own if I would not go forward with this motion in his behalf. And we had a civil discussion about this, Judge. We did not have a fight or anything. I want to make that clear. Mr. Peterson and I have a good relationship, speaking-wise, so I'm not trying to cast aspersions on him at any point. I want the record to reflect that. But this is an impasse that we have reached, and that is the reason I have brought this to the court's attention.
Okay. All right, the court will note that there was a motion that was filed today asking for this court.
For the videotape, hearing a bell and charges.
Okay, we don't have videotape. You can request a transcript, certainly. That's, yes, you can certainly request a transcript.
Yeah.
You don't need a motion for that. You can request a transcript without a motion, just so you know.
Okay, well, we did it over Zoom, so I just assumed that you'd have a videotape of it and not a transcript of the 7th, of January 7th, when we had a bail bond discussion and the charges of trespassing and assault in the city of Woodhaven. We did it over Zoom.
I understand we did it over Zoom, but we don't, that was not recorded over Zoom.
It was just on
recorded
transcript.
on our transcript.
Okay, well, I'm gonna have to file a motion for that, I guess, because I don't.
No, sir, what I'm saying is that you don't need a motion for transcripts. You can just request the transcripts.
Okay, yeah.
There's a fee that you have to pay, but
I love watching this judge. Fair, no nonsense, and absolutely unafraid to call out a defendant who thinks they can get away with breaking the law. It's rare you see a judge who has both the patience and the authority to stand their ground like this. Gregory's been in and out of this courtroom, ignoring all the rules, and now the judge is setting a bond and basically telling him one more screw up and you can just walk straight to jail. Let's see how long this generosity lasts.
3, I believe it's filed that on the 17th on Friday or something like that. So
okay, hold on, just a moment. Okay, well, counsel, I will allow you to, I will grant your motion to terminate representation specifically as far as moving forward, but counsel, I would just, if you can just stay on these proceedings.
Oh, of course, I would ensure, yeah, I have no problem.
Let me finish, please.
I'm sorry.
To advise Mr. Peterson appropriately if he's getting into some territory he shouldn't be getting into, okay?
Of course, Judge.
Thank you. So the motion you filed today, sir, is regarding the Zoom video that does not exist, but the transcripts you can certainly request, correct?
Yes.
That's all of this one. You filed something on January 17,
Mm-hmm.
and you're requesting under 2.003 to dismiss, disqualify the judge as follows. File the motion in good faith. Fair bond conditions and restrictions to stop U.S. public protests at City of Winnebago Public Schools are biased favors given to plaintiff. Okay, well, sir, I can tell you that that's not, that's a condition this court put in because that's what's alleged as a violation. So to protect the complaining witnesses, that's what the court put in. Just as in any assault case, sir, I put a no contact provision in. And so that is why I did that, not because there's any bias at all.
Well, if you keep
Not
reading,
at all.
If you keep reading, Your Honor, you'll see that the U.S. Federal Court, Judge Grant, Your Honor, because the city of Woodhaven tried to put a PPO on them, specifically told them, case dismissed, that he cannot.
Here's where things get really interesting. In front of a courtroom full of kids, this defendant Sullivan decides to drop the F-bomb. And not just any F-bomb. She's literally challenging the judge. Big mistake. Look at the judge's reaction here. Immediate, no hesitation, and with full authority. The words "take her into custody" were basically a guarantee that Sullivan was going to feel the full force of the law. This isn't the place to play badass, especially with children watching. You can feel the tension building as the judge decides enough is enough.
I'm not trying to violate your constitutional rights. What I'm trying to do is that there is, right now, that there's a complaining witness. There are allegations, and so the court, as condition of bond, has put certain parameters and conditions of bond on. Just as, like I just stated, just as if there is an assaultive, somebody with assault and battery or domestic violence, they're not allowed to return to the home or wherever the victim lives. They're not allowed to return to the victim's place of employment. They're not allowed to contact the victim. Those are all conditions I put in. Somebody with disorderly conduct, I put certain provisions in there, whether they can use alcohol or not use alcohol, whether they have to use testing or not testing. It's not intended to violate any rights under the U.S. Constitution. The purpose is for protection of the complaining witnesses and protection of society if this court deems necessary.
That's if somebody violated a law. I haven't violated nothing.
Sir?
I'm with you.
The allegation is that you assaulted, resisted, obstructed a police officer causing injury and trespassed.
That's
Now,
just an allegation.
you're correct. But as a condition of bond, there are certain factors the court has to take into consideration when assessing bond, and the court has judicial discretion to assess bond conditions. That is what this court did. I didn't place you on house arrest, told you you couldn't move anywhere. I didn't do any of that, sir. I simply put forth conditions relevant to the allegations therein. And sir, I'm very much aware that they're allegations only.
Yeah, you need to read the whole thing, other than just one. I got like 15 issues in there.
15 issues.
Yeah, you
Okay,
need to
so
read the whole thing. Also, Your Honor, I publicly protested today in front of your court,
okay.
but none.
Okay, did you catch that? The judge just gave her a hard lesson in what happens when you mouth off in court. It's one thing to push back with words, but it's a whole different story when the judge has the power to throw you in jail. The fact that she didn't take this seriously earlier is honestly baffling. She was already in the system and decided that disrespecting the judge in front of kids was a good move. Yeah, that's not how it worked.
I followed your white laws. I followed them. And then you stomp on me when I followed your laws. You've been doing this for hundreds of years. You know, Martin Luther King marched, and you guys took dogs out.
Stop right now.
You
I'm
violated
not
our
100 years
rights.
old, so do not accuse me of stomping on anything.
Well,
Let's be very clear on that.
yeah, well, okay. Yeah, it don't seem like it.
I'm not 100 years old, sir. Were you interfered with at all while you were engaging in your protest?
My constitutional right? No.
No, you were
I
not.
did at the city of Woodhaven, though, and now you condemning me for it
No,
because
sir.
you restricted me.
Sir, let me be very clear.
I've committed no crime.
I am restricting, I put conditions on for the protection of the complaining witnesses which is the authority that I've been given with my judicial discretion.
You also,
Yeah.
you also took an oath to uphold every citizen's constitutional right to public protest. But
Okay.
you're not doing that.
Sir, let me clarify. Let me clarify something. There is a balancing act that as judges we have to do. So we have you're charged with a crime, right? It's an allegation. We have the protection of the victim and the community. All right? So there's a balancing act that this court has to do. And that is what this court is doing. I have not restricted all of your movement. I have not said you can't put signs up anywhere, you can't go on any public property. I have not done that, sir.
You did.
No, what I did was I addressed specifically the complaining witness and the victims in this matter. That is what I did, and that is what I have the authority to do that's been given to me by the US Constitution as well. That's statutory authority. Whether you agree with that or not, sir. I understand you don't agree, but that's not a basis for this court to disqualify itself. Let's see what the next one is here. Okay, I don't know what bias favors are. I'm not biased, prejudiced, discriminating against you in any way, sir.
That's your opinion.
And sir, let me just be very clear. The court has not infringed on your First Amendment right of free speech. What it did is it put in protections for the victim in this matter.
I'm the victim.
Which this court has every authority to do.
I'm the victim, and you're not recognizing that. I just protested in front of your courthouse and it was okay. You should have arrested me then. When I go to your school.
All right, now that we've seen how one reckless defendant got their reality check, let's switch gears to a different courtroom. This next one's going to get messy. We're heading to Judge DeSanto's courtroom, where we're about to see a legal showdown between a defendant who thinks the whole system is out to get him, and a judge who isn't here for any of that nonsense. Spoiler: when someone starts throwing around accusations of racism without evidence, you better believe the judge is going to call them out.
Authority to arrest you myself.
Well, they don't either. They took an oath to uphold my civil rights, whether they like it or not.
Sir, did anybody arrest you here?
You weren't supposed to. It's my constitutional right to do. Just like in the city of Woodhaven. This is what I'm trying to get through to you. You're trying to say, no. There's allegations against you that you did this, and this. I'm trying to tell you I exercised my constitutional rights, and they violated me. I'm the victim.
And sir, that is everything that will come through discovery and whatnot. At this stage, this is considered pre-trial.
I know what this is.
So
I've been through your system before.
So
also, Your Honor, I've asked if you don't dismiss your...
I think things couldn't get any more ridiculous. We have Bradley Peterson accusing everyone in the courtroom of being racist. But here's the thing. Judge DeSanto isn't even fazed. This isn't some rookie judge who's going to cower in front of these baseless accusations. He's calling it what it is: frivolous motions and pointless distractions. There's a reason the attorney wants to